This Honorable Court of Tennessee is now back in session. You may be seated.
Madam Clerk, will you call the next case, please?
Foothills Land Conservancy versus Creekside Estates Partnership et al.
Good afternoon.
Yes, sir.
Lewis Howard of the Knox County Bar here on behalf of Creekside Estates Partnership. I'd like to reserve 4 minutes for rebuttal if I could.
You can.
This case, I won't belabor the facts. I'm sure you're aware of the factual background, but this case arises out of an easement agreement and some reserved rights that were granted or actually retained by the grantor in connection with a conservation easement. Those reserved rights were, in essence, all of the property rights of the grantor that were not granted as part of the conservation easement, and specifically included the right to build 10 residential structures on the property. There was a process laid out in the easement consisting of sections 4 and 5, which comprise about 6 to 8 pages of the easement, setting forth that process. And the process involved, once the grantor was prepared to exercise those reserved rights, they would submit a request in writing to Foothills for consideration. The standard there was for Foothills to consider whether or not that proposed activity had a material adverse impact on the conservation values. And if it did, they would give feedback to Creekside, which would change its plan. So this process, the easement was actually granted in 2007. The first request to do anything was in 2017, and that request was initially to build 10 houses. That was subsequently changed down to 8 houses. A plan was submitted, and the parties went back and forth. Then in August of 20, there were some additional revisions made to the plan that was submitted, and there was no further feedback from Foothills on that. Foothills sent an email saying, we have your plan, here's the process that it's going to take, and we'll make a decision at our October 20 board meeting, and we'll let you know. And the requirement that we be advised in writing of whatever decisions made. So Foothills held the meeting, voted down the plan, but did not advise Creekside that it had done so. In a meeting 2 days after the Foothills board meeting, the executive director advised the principal of my client, Mr. Ayers, that no action had been taken on the plan, but that if they wanted to try to submit a fewer number of houses, that particularly might fly. Subsequently, Creekside recorded the plan under a provision under Section 5 of the easement that said that if no action was taken within 30 days, the matter was deemed approved. There was a subsequent lawsuit filed by Foothills for declaratory judgment with respect to that deemed approval clause, and that deemed approval clause has language in it that has an except where provision. The trial court interpreted that except where provision to control the process of review and approval of the proposed building sites, and we cite that as the principal error the trial court made. There's also an error we believe, with respect to awarding attorney's fees. But the problem with the trial court's interpretation of the except where clause, it is clearly, just in reading the document as a whole, it is a fail-safe clause. It is designed to prevent a situation where a proposed activity is strictly prohibited by the easement itself or clearly destructive of the conservation values, such as putting a proposal before Foothills over the Christmas holidays for a zinc mine or a rock mine, or to pave the entire property, something that is clearly destructive and strictly prohibited. If it's strictly prohibited, it can never be deemed approved. But the exercise of reserved rights are never strictly prohibited or never clearly destructive of conservation values. They follow a process where the plan submitted, it's to be reviewed by Foothills Board of Directors under a reasonableness standard as to whether or not it has an adverse impact on conservation values. Never under a standard of is it clearly destructive or strictly prohibited. And what happens with the trial court's ruling now, we are removed from this whole process in Section 4, where there's a deliberative process under a reasonableness standard, and the trial court has substituted now a clearly destructive whereas exception clause, so that Foothills no longer has the obligation to use reasonableness in connection with their consideration of exercise of reserved rights. They can actually do nothing. They can take no activity whatsoever.
So what is the standard then, from your perspective, of when your client presents plans to Foothills? How do they decide whether or not it's okay under the easement or not okay?
The requirement is that they review it to see if it has a adverse impact on the conservation values. And if it does, it has to be tweaked.
And that's per the language of the statutes, right?
No, that's the language in Section 4 of the easement.
Of the easement, okay.
That's specifically in Section 4 of the easement. And so the contemplation, obviously, in just the clear language of the contract, was the parties would go back and forth until the proposed plan did not have an adverse impact. But the right to build 10 houses is there. It's unrefuted. It's a retained property right that the grantor retained when it granted the conservation easement. So at the time the conservation easement was created, it was created with the assumption that there would be 10 residences on this 40-acre property. And you've got to understand that the background of that was this property was phase 3 of 4 phases of Bridgemore subdivision, and was approved for 76 single-family residences. In 2007, when this easement was executed, this was deemed to be a downzoning concept that it apparently is not popular now in conservation easements, but was at the time. And so you create this conservation easement by eliminating the 76 houses down to 10 houses. The process now we're left with, based on the trial court ruling, is Foothills doesn't have to do anything except say that something is clearly destructive. There's no standard applicable to them now, and there's no process for us to do anything other than to come back into court again on a declaratory judgment suit and challenge that activity. What it does is it takes what was negotiated between the parties, an agreement that had a 6-page process of here's how we go about exercising our reserved rights and moving forward. And you'll look at the plan, you give me comments on the plan, we go back and forth until we develop something that meets the conservation easement and meets our requirements. Now this has been outsourced to a third-party expert witness, whomever Foothills hires, to come in and say, oh, building any houses there is clearly destructive, you can't do it. So Foothills then doesn't have to give us any notice. They don't have to comply with a 30-day requirement to give us a yay or nay after we submit our plan. And we submit that that is simply not what the document says. And it's an inappropriate interpretation and inappropriate application of that clause. Exacerbating that problem was the trial court's consideration of an appraisal, which was prepared and used in connection with the charitable tax deduction. The appraisal contained a number of things, but one of them was a proposed lot layout, which was a diagram of 2 cul-de-sac roads showing 10 houses on it. The trial court found that that plan looked substantially different than the plan that Creekside had submitted, and that was evidence of what the parties contemplated at the time the easement was entered into. The appraisal wasn't prepared until 3 months after the easement was executed. The appraisal wasn't part of the easement, and Foothills was not a party to the appraisal. There's absolutely no evidence that the parties contemplated any particular layout or type of arrangement of lots at the time that they entered into the agreement, and we think the trial court erred in considering the appraisal in that regard. I don't want to miss my final issue, which was an award of attorney's fees. The trial court awarded Foothills about $231,000 in attorney's fees, finding that the action that was filed was an action to enforce the easement rather than the declaratory judgment suit, which it was. It was filed as a declaratory judgment suit. There was no allegation of a present violation. There were allegations in paragraph 40 and 44 of the complaint, which say that if Creekside were to go forward with its development plan, that development plan, the construction of the 10 houses, would violate the easement because it would destroy the conservation values. And it references Section 6. Well, Section 6 of the agreement is what has the whole process, and my time's up, but it has a...
Go ahead and finish your point, though.
It has a process of, if there is a violation, Foothills is required to give written notice, and there's a 60-day cure period. So there was no notice given of a violation and an opportunity to cure, and there was no specific reference in the complaint of a specific violation. The complaint just says, if you went forward, it would violate it, and we would be entitled to the remedies under paragraph 6, which included attorney's fees, but it's kind of a circuitous argument when there's no notice under Section 6. And I'm out of time, and I appreciate you.
Thank you. You have your rebuttal time. Yes, sir.
Please, the court. I'm Morris Kaiser. I represent Foothills in this case. I do disagree with Mr. Howard about some of the recitation of the facts. The document, controlling document, is, of course, the conservation easement itself, and the regulations pertaining to these things, the IRS regulations, are incorporated in there. Now, the proposed development, the plat at issue, and it's not just a proposed development, because once Creekside recorded that plat, it sold one of those tracts for, I think, $500,000 to the Langfords, who are also parties to this case. But in any event, that is the development issue. It is a map. It's Exhibits 8 and 9. It's attached to an email that Mr. Ayers sent to Foothills on September 2, 2020. There was no agreement about that concept between the parties. There was no agreement whatsoever. Frankly, and the court found this, is that the email was not sufficient to trigger the obligation of Foothills to give a response, or it could not trigger the deemed accepted provision in Section 5B of the easement. And specifically, it was an email. The contract required a written notice sent by hand-delivered or sent by first-class mail. The second issue is the email never said we're submitting this for approval, and more importantly, attached to the email was the concept plat. We call it the Creekside plat in the record, and it was lacking in essential things that needed to be shown for purposes of Foothills to make a determination about whether to approve it. And those included locations of easements and locations of driveways, and it also included also it's the the plat is breathtaking in terms of the amount of property that is taken up in the process of the easement. And of course, one of the easement purposes and the conservation purposes is that the property is retained forever in its undeveloped, natural, scenic, forested, and/or open land condition to prevent any use of the property that would interfere with the conservation easements of the property. All that is set forth in our brief. Now, the codes, or rather the contract section Mr. Howard refers to is section 5B. And what it says is that once submitted, Foothills reviews it to determine if the proposed action would be inconsistent with any of the conservation purposes of the easement, detrimental to the conservation values of the easement, prohibited by or would be inconsistent with the restrictions set forth in the easement. Then here's the operative language. If grantee does not approve or withhold approval of the requested action within 30 days of receipt of grantor's written request, therefore, grantee is deemed to have granted approval of such requested action and grantor is expressly authorized to proceed therewith, except where, in all caps, except where the requested action is clearly prohibited by the terms of this easement or be clearly destructive of the conservation easement. As I said, it is Foothills' position that it never received notice that would trigger a response. But of course, Mr. Howard argues otherwise, and he's saying that the approval is deemed to be approval because he said Foothills never responded within the 30 days. And again, it is not agreed to it or denied. It is agreed to it or withhold permission or withhold approval. Now, at the trial, the expert witness for Foothills was a man named Lloyd Raleigh, and Mr. Raleigh testified as to the plan, the Creekside map. He said it would have a material adverse effect on the impact on the conservation values and the conservation purposes. He said it would be clearly destructive of the conservation purposes of the easement and would render the purpose of the easement impossible to accomplish. He talked about the fragmentation of the open space. He said there was a major factor in the decline of native wildlife species, a destructive effect of wildlife habitat, both of which are conservation purposes in the document. He said it would have a devastating impact on scenic and panoramic views. He said it would turn the property essentially into a residential development. And he said there would be no significant public benefit. And if you look at the plat, it's really true. It looks like a West Knox County residential subdivision layout. I mean, the entire property is covered up with 8 tracts spread across 40 acres, each of these tracts 5 acres each. Leaving, virtually gutting the entire conservation purposes. The court found that Mr. Raleigh was qualified, credible, and persuasive, and credited Mr. Raleigh's testimony over the testimony of Creekside's expert, who said there was no problem here. And then based on this finding, the trial court made the specific finding of fact in the first opinion it entered that the development plan submitted by Creekside, which is Exhibits 8 and 9, as shown on that map, is clearly prohibited under the easement and clearly destructive of the conservation purposes. And that finding is exactly the except where in section 5B, except where the requested action is clearly prohibited by the terms of this easement or would be clearly destructive of the conservation purposes. So Creekside is saying, we submitted a proper request. We did not get a response within 30 days under 5B of the easement. It's deemed approved, and as soon as that happened, Creekside records this plat, sells one of the lots for $500,000. They went forward with the development. So the lawsuit, of course, ensued. Now, Creekside is taking the position, Mr. Howard said, that in the exercise of its reserved rights, you never get into the except where situation. In other words, it could never be clearly prohibited by the terms of the easement and could never be clearly destructive of the conservation purposes. That is not what the document says. Moreover, it is contrary to the regulations which are incorporated into the agreement. It's contrary to the terms of the agreement. And at the risk of boring your honor somewhat, I do want to read a couple of those provisions because they're pertinent, absolutely pertinent to this point. And again, some of these are regulations, some are provisions in the easement, and again, the regulations are incorporated into the easement. In the regulations, it says the reserved rights must conform, the reserved rights being the ability to build 10 locations, and that is in there, there's no question. But those reserved rights must conform to the requirements of the regulation. A deduction will not be allowed if the terms of the easement permit a degree of intrusion or future development that would interfere with the essential scenic quality of the land, or if the contribution would accomplish one of the enumerated conservation purposes, but would permit the destruction of other significant conservation purposes. And this is the most important one in my view. The easement says there is no assurance that the reserve rights for which Foothills consent is required may be exercised in the manner proposed by Creekside. The reserve rights cannot be exercised in a manner which is adverse or detrimental to the conservation purposes, conservation values, or other significant ecological values of the property, or which is prohibited by or is inconsistent with the restrictions set forth in the easement. The easement says Creekside may not exercise any of its rights reserved under this easement in such a manner to adversely impact the conservations of the property. And then it goes on to say that the Creekside must show the locations of the house's improvements, and it goes on and says, and they must not unreasonably interfere with the conservation values. So it's absolutely incorrect to say that in the exercise of its reserve rights, they can never be in a situation where what they're doing is clearly prohibited or clearly destructive. And
Mr. Kaiser, let me ask you this, and part of it is just my unfamiliarity with conservation easements and the law surrounding that. But who decides whether or not something is clearly prohibited or clearly destructive versus it defeats the purpose, versus the other standard that's in the easement, which is clearly and then if you're going under the other standard, who decides whether it's defeats the purpose of the easement? Like, is there a body of case law that establishes some standard for that? Otherwise, it seems to me you could be subject to all kinds of differing opinions about whether or not the development goes too far or it's okay.
Well, Your Honor, it's a case-by-case analysis. Each proposed development is different. Each piece of property is different. The conservation purposes and the easement purposes stated in the documents vary from document to document. And it's, as was the case in this particular action, it was a matter of expert opinion. Mm-hmm. And Mr. Raleigh was retained, gave his expert, the court credited his testimony. Creekside presented an expert, Mr. Jackson, who frankly, a wonderful geologist, but not in this field. He was not qualified and he had no experience in this.
And is that what typically happens in these cases, is you just have a battle of experts? One will say one thing, the other will say another, and the court just picks?
Your Honor, this is the first one I've been in, so I can't say what typically.
I thought you were some guru on conservation easements. All right.
I'm sorry.
You're fine.
Matter of fact, I didn't even try the case, so I can't even say that. So I'm sorry, I can't answer your question.
All right.
Then, Mr. Howard mentioned the appraisal. The appraisal was for the purposes of being able to take the tax benefits involved in this situation to determine what those are for purposes of IRS consideration. The appraisal showed that before the burden of the easement, the property was worth $4,200,000. As burdened by the easement, it was worth $475,000. The deduction to the grantor, Mr. Howard's client, $3,725,000 was the charitable tax deduction they received. That's a 42-acre tract. Part of that involved the submission of a plat that had to go. It was a requirement. What placemakers had to send in was the conservation easement, and they had to send in an appraisal to support the deduction. And so attached to that is a plat that's Exhibit 3. It shows 10 lots spread out over 2+ acres with rights of way of 4+ acres, leaving the rest of the property, about 36 acres, undeveloped. Mr. Howard said that was never part of the agreement. I submit to your honors that it was submitted by placemakers under penalty of perjury to establish a charitable deduction of $3,725,000, and it is a submission that shows by Creekside that shows this is consistent with what we're asking the IRS. It wasn't written in the contract, but it's a submission, it's a speaking by Creekside to say, here's our understanding of what we got. It's also probative in that it shows that, yes, 10 lots can be put on this property. It can be done because the IRS accepted it. I'm running out of time. I need to address attorney's fees. Mr. Howard said that this was a deck action. Clearly, there's a case cited in the brief that says other causes and claims can be added to deck actions. Attorney's fees were clearly requested. In the complaint, Foothills said it's bringing the action to enforce the terms of the easement and so forth. And so clearly enforcement was requested. And we also said that what they're doing is prohibited by the easement. The trial court found that what was done by Creekside was prohibited by the easement. And there were some proceedings in connection with attorney's fees as to whether or not prohibited by meant violated the terms of the easement. And the trial court clarified that day, that yeah, when I say it's prohibited by the easement, that means the same thing as it's violated by the easement. Matter of fact, there was exchange between the judge and Mr. Howard, where Mr. Howard basically conceded that point. So yes, there was a violation of the easement that was within the terms of the operative language of our entitlement to attorney's fees. And the claim clearly falls within the language of the contract that permits attorney's fees to be awarded. Now, Mr. Howard says under Section 6A of the easement that Foothills did not give Creekside notice of breach and opportunity to cure. The trial court agreed that notice and opportunity to cure is in fact an affirmative defense, which was not raised and is therefore waived under Rule 8.03 of the Tennessee Rules of Civil Procedure. Also, notice was not required for several other reasons that are set forth in my brief. And I'm running out of time. This is the fastest 15 minutes of a lawyer's life arguing before this court.
Sometimes it feels like the longest for us. Not today.
I don't doubt that. I don't doubt it. But I would ask your honors to look at my brief as to the rest of the discussion about attorney's fees. And also, Foothills presented 2 issues for review, none of which should be too controversial, and would request your honors to consider those and basically ask your honors to affirm the trial court in all respects, to remand this to the court for an award of attorney's fees for Foothills as a result of this appeal, or in the alternative to remand it for consideration of the alternate relief requested by Foothills. Thank you.
Thank you, sir. Your rebuttal?
Thank you. I would like to address the notice issue just briefly. The Section 5 of the easement agreement provides for written notice, and the notice provision says, the notice shall describe the nature, scope, design, location, timetable, and any other material aspect of the proposed activity in sufficient detail to permit grantee to make an informed judgment as to its consistency with the purposes of this easement. The notice was an email that was sent from David Long to Foothills. David Long had been acting as an intermediary between the parties, trying to get this RSAs, the residential structure areas outlined on the plat, to everyone's liking. Foothills then sent a email out on September 15 from their executive director that says, we have your plan. We've not made a decision on it. We're going to hire a biologist to assist us in making that decision. We're going to hear it at the October board meeting, and we will let you know. And so they did that. They took the plan, they took it to their board, and they voted on it. And they did not, according to the minutes of the meeting, say anything about it being clearly destructive or clearly prohibited. The minutes just simply reflect the plan was not approved. Foothills then told Mr. Long that no action had taken place at that meeting. Mr. Long recused, he's on the board, and he recused himself from that meeting. 2 days later, Mr. Claybo and another board member met with Mr. Ayers and told Mr. Ayers the same thing. No action was taken by the board, and you need to come back with fewer houses. It wasn't until Foothills filed this lawsuit and we went through discovery that we found out that the board minutes reflect action had actually been taken. So they got the notice. It's not personally delivered, and it was not first-class mail, it was via email, but they had the notice, they acknowledged the notice, and they acted on it, and we specifically pled waiver with respect to that regard. Excuse me, I think the court erred in not finding so. With respect to Mr. Raleigh's testimony, and this dovetails into, Justice Davis, your question, who makes this decision? Our position was this was an interpretation of law. To interpret this agreement as a matter of law, what does this provision say? Not, are we going to get experts in to say, well, 5-acre lots are intrusive. Mr. Kaiser made the comment that this looks like any other subdivision in West Knoxville. I beg to differ. I've seen a lot of subdivisions. There are very, very few of them that have 5-acre lots with one house on each one of those lots over a 40-acre period. There's a ton of open space. The whole concept was that there would be open space. There would not be 76 houses. There would be 10 houses. So to your point, Your Honor, Mr. Raleigh doesn't get to make those decisions. It's not a battle of the experts. It's an interpretation of the document. Foothills did not raise this issue in trial court, and they put it in their on page 14 of their brief, which they said, by making the easement pursuant to the regulations, placemakers and Foothills incorporated the provisions of the regulations limiting the exercise of any development rights reserved by placemakers. That point was not made at trial. There was multiple references to the regulations, but there's a specific case that we cited to the court, this Coal Property Holdings case, which involved Foothills, which says that easement deed that contains a Treasury regulation override mandating these provisions be interpreted to conform to the regulatory requirements as we have construed them. We conclude that the text to which petitioner refers constitutes a condition subsequent savings clause, which we and other courts have consistently declined to enforce.
Thank you.
Mm-hmm.
Thank you both for your presentation. This case has now been submitted to this court for resolution. You should receive our decision and opinion within a reasonable period of time. Thank you both.
Thank you.
The attorneys may be excused. Madam Clerk, will you call the next case, please?
In Ray Mitchell C.